rare and balanced view on politics in today's world. Based on facts, born of rationality, common sense, and logic, providing context on today's events, this is American Perspective with Rick Thomas.
Hello, Whiskey Warrior P1s. It is a Monday. It is a great Monday. It is a fantastic day for the MAGA crowd, the Make America Great Again crowd, of course. That's I'm stealing that from Buddy. Buddy Weiser over on Rumble said that it's a great day for MAGA, and he is not wrong. I will explain in just a few minutes about that. But hey, we had a fantastic Thursday night with a wonderful debate. Then we had a fantastic Friday. And as anticipated, we have a fantastic day here on this Monday. Yes, the final cases of this session at SCOTUS have been handed out. And one of them, I got to tell you, the one that we've been anticipating forever is just absolutely astounding. Not necessarily for the court's opinion or the majority opinion, but also for the great American, the wonderful constitutional jurist, one of two that we have on the court. The fantastic Clarence Thomas just absolutely rips the appointment of Jack Smith, and I'll get into that as well for tonight. Got a lot to cover, fantastic stuff happening. Let's go ahead and get it kicked off here with our own Buddy Weiser over on Rumble leading us in the Pledge of Allegiance. So please, if you are of mind, please stand, remove your hats, and, put your hand over your heart, of course. And let's all join in with Buddy on the Pledge of Allegiance.
I hereby pledge my allegiance to the flag of the United States of America and to the republic for which she stands, one nation under one God, indivisible, with liberty and justice for all her citizens. So help me God.
And I thank you, Buddy, for that submission. If you would like to get your pledge, your rendition of the pledge put here on the program, you can do it by sending it. Record yourself doing it first. I mean, that's obvious. And then send it in to my email address, fans, F-A-N-S, at AmericanPerspective.online. That's fans, F-A-N-S, at AmericanPerspective.online. And that will get you into the rotation. And believe me, I need to get some more. I will always welcome more, but I've got a few in the background, so you guys are not listening to me all the time. That is awesome. I do appreciate that. Okay, tonight's wonderful sponsor, of course. You see all these wonderful patriotic-themed shirts that I wear every single night here on the program. They all come from theflagshirt.com. That's theflagshirt.com. And unfortunately, you missed the opportunity to get your shirts by the time Independence Day arrives. Unfortunately, that ended today, so you kind of missed it, but that's okay, because I know that all my Whiskey Warrior P1s, as well as all of you other folks who are watching this program, you're all patriots. You all love this country. You all love the red, white, and blue. And so you should go and check it out. Theflagshirt.com. They've got styles for men, women, kids. They also have all kinds of additional accessories like sunglasses, socks, ties, just hats. They've got all kinds of stuff over there. Caps. They've got all kinds of stuff over there. So you need to go to theflagshirt.com and check it all out. If you purchase $75 worth of product, you will get free shipping. But you know what? I'm going to throw in a little bit of an extra for you. If you go to flagshirt.americanperspective.online, that's right, that's flagshirt.americanperspective.online. If you do that, you will get a promotion code to get you $5 off your order. Head on over to flagshirt.americanperspective.online and get yourself a promo code to enter in at checkout at theflagshirt.com for $5 off your order. Go to theflagshirt.com and get yourself patriotized. All right, let's go ahead and get this started off and kicked off in a fantastic way. I don't know if anybody has noticed in terms of the world, but it seems like we're not the only ones that are shifting, let's say, in our political perspective. And it's not just a political perspective, it's also a social perspective, all right? But we're not the only ones. See, the French held some of their elections here in the last couple of days. And let me go ahead and get that. And it looks like the French are voting for conservatives. So I don't pretend to understand how this stuff works, but I just want to point out that there is apparently several rounds of elections that go on. And in this particular case, French voters propel conservatives to a strong lead in the first round of these legislative elections. Well, this is a good thing. And part of the reason for this actually has everything to do with the influx and invasion of immigrants into their country that are essentially, for the most part, Muslim immigrants, and that are causing all kinds of problems within the country and within the French society. And so a lot of the apparent public has decided that this is no longer a good thing. Well, here's one of the problems, and I'm going to tell you too, folks, this is what I expect to have happen here in November. So we've got to keep our heads on a swivel the closer we get to the elections. But here in Breitbart, a Le Pen victory, that's one of the electorates, the Le Pen victory triggers leftist protests. So they started protesting and they were burning stuff and doing all kinds of different things over there. Thousands of people turned out to protest the outcome of the first round of the French parliamentary elections on Sunday night, objecting to the French people having voted in greater numbers for Le Pen's populists than the pan-left bloc. Now, folks, this is what's going to happen over here. I mean, the left had been dealt a serious couple of blows over the last, a few blows over the last several days. And now, I can just tell you right now, this is just kind of a precursor. This is a glimpse as to what the leftists over here may end up doing. In fact, they're already calling for it. You know, when the SCOTUS issued the decision, they went nuts and all over on X and everything else. And I've got a few things on that, but let's talk about the Trump immunity case. The Supreme Court ruled that presidents, no matter which side, no matter how long ago they did their things, they have substantial protection from prosecution. Now, here's the thing, though, and this is something that the left looks at everything in a all or nothing scenario. They don't understand, and it probably has something to do with the fact that they don't really have much in the way of reading comprehension. I mean, let's be honest with you. They want to tear down all of the standards for education in order to make it easier, for people to actually pass in our educational system. That's essentially what they've been doing over the course of the last several decades. But realistically, here is what is essentially a common sense and very logical decision. In fact, I floated it here on this program as well as on my social media accounts. There is no way that you can expect somebody to get into the Oval Office and not have immunity for some of the decisions that they are undoubtedly going to have to make. I mean, for an example, let's just take a look at the whole COVID response. Okay. Well, the whole COVID response, Donald Trump makes a mistake. He, sides with somebody who is supposed to be an expert, and all of a sudden, billions or millions or hundreds of billions or whatever people die. And so what happens here is you can't go after him for that official act, whatever that act actually was. And that's essentially what the Supreme Court, decided. And it was the actual opinion, the concurring opinion, was written by Chief Justice John Roberts. And he simply explained that as long as it's an official act and it's an act where the president is performing his constitutional duties, no matter where it is, okay, that is not a problem. In fact, him talking to his vice president about the elections are potentially something that he would be considered immune from prosecution, because that would be could potentially be considered part of his official duties, is to make sure that our elections are run properly and without illegal interference. I mean, that's what the executive branch does, is enforces the laws of this country. And so that being said, this does not bode well for any of the cases that are up against Donald Trump right now, especially the Jack Smith ones, as well as potentially Fani Willis's one in the state of Georgia. Because as you recall, Fani Willis actually has a corruption, a part of the RICO case where he made the call to Brad Raffensperger, whatever his freaking name is. And that phone call was included as a part of the entire case. And so this is why Trump's immunity case was so important. Now, of course, it was decided in a 6-3 decision. The three morons, of course, the activists on the court, the not constitutional jurists, they went ahead and took the other side of it and said, like the left pretty much did afterward, is, well, what happens if he decides to kill his political opponents or do something else? He can't have immunity. This isn't because, no man is above the law, so on and so forth. But you have to read and understand what Chief Justice Roberts and the other five, I should say, what they did in terms of explaining how this works. The keys are in the delivery of the opinion with regards to the fact that it has to be an official act. It cannot be an unofficial act. It has to be within his or her constitutional boundaries as to whether or not this person as president can actually gain immunity. Now, a concurring opinion, yet one that picked up on something else, came from Justice Clarence Thomas. Now, I got to tell you, I admire this man. I admire him like nobody's business. He is a awesome jurist, a strict constitutionalist, and is just fantastic in this conversation. So if you scroll down within, and I'm doing it on the screen here, you can take a look, but if you scroll down within the opinion, And I do have the opinion in the show notes, so you can click on that link and go and get the actual text of the opinion, and you can read it for yourself. You can download it and read it for yourself. I'm still debating on whether or not I actually want to save this or not. But one of the things that is just absolutely amazing on all of this is the fact that he talks about, so this is all part of the opinion. I got to get further down. Sorry. But Clarence Thomas talks about the illegal appointment, the unconstitutional appointment of Jack Smith. And believe me, this whole thing is really, really long. The actual opinion of the court is really long, and it goes down here, but I gotta do this. But remember when I told you that during the line of questioning on this particular topic in this particular case, Clarence Thomas did bring up the idea as to whether or not Jack Smith was unconstitutionally appointed as special counsel. And so here, I finally got to it. It's on page 52. It's like halfway through. But on page 52 of the opinion, and he basically, Clarence Thomas basically lines this out in terms of the fact that the Constitution itself was violated. Now, if you remember correctly, like I've been telling you, the fact that the Constitution itself is a protection in terms of the appointment of rogue prosecutors, such as Jack Smith. He basically points out that he concurs with it, but that the office of the special counsel has not been established by actual law as the Constitution requires. Now, what he's talking about here is that the office of the special counsel has not been created by the Congress. It was created as a procedural aspect within the Department of Justice. And so this is where the question comes into play, because it requires the Constitution in Article 2, Section 2, Clause 2. It requires that Congress actually create the federal offices. And since Congress has not done that, the question that Thomas brings up is, because of that, Jack Smith can't really sit in that chair because there is no official constitutional way that office can exist. Because the Constitution imposes the fact that the president cannot create offices just on a whim. Now, if there's no actual law establishing the office of the special counsel, then he cannot proceed with the prosecution. A private citizen cannot criminally prosecute anyone, let alone a former president. Now, he talks about the appointments clause, in which he says the president shall nominate, and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. That's the key. But the Congress may, by law, vest the appointment of such inferior officers as they think proper in the president alone, in the courts of law, or in the heads of departments. And that's Article 2, Clause 2. So the default manner, according to Thomas, for appointing officers of the United States is a nomination by the president and then a confirmation by the Senate. Now, it does provide a limited exception for the appointment of what's considered inferior officers, whereas Congress may by law authorize one of the three specified actors to appoint inferior officers without the advice and consent of the Senate. But what's relative here is that Congress, as far as he knows, as far as he has written, Congress did not authorize by law the appointment of a special counsel. So the Constitution requires that the underlying office be established by law. The Constitution creates some offices, which is like the president, vice president, but it also contemplates the fact that there are going to be others, but it clearly requires that those offices shall be established by law. So he's basically calling out Merrick Garland for, hey, you created this thing, which, ironically, this also actually shoots down Durham. It shoots down Mueller. It shoots down any of the special prosecutors by that argument until such time as Congress creates the position. In considering the fact that Congress hasn't created the office by statute, which would mean that it would be a consistent, and this was an argument that I talked about before, was that it would create a consistent office that would obviously always have to be filled. The office of the special counsel, as of right now, can be set up or torn down at whim. So it would end up being a situation where Congress would have to actually define all of that in law. Not to mention the fact that it would be considered an inferior office and not a major office, which basically means that the office of the special counsel wouldn't have carte blanche, full control like what Merrick Garland has basically described in Jack Smith. So Clarence Thomas continues here saying the limitation on the president's powers to create office grew out of the founders' experience with the English monarchy. The king could wield significant power by both creating and filling offices as he saw fit. So there you go. This goes all the way back to the founders. So Clarence Thomas is essentially calling out Merrick Garland for setting up this office that doesn't have a constitutional backing, nor does it have congressional backing. And he goes on, there's a good long thing talking about the long-withstanding practice, from the original understanding that Congress has to create those offices. For an example, he puts in the first Congress routinely and explicitly created offices by statute, where he created the offices of they created the offices of the Attorney General and the U.S. Attorney for each district. Now, keep in mind, that's all because Article 3, which is the judicial system, wasn't completely fully fleshed out when they finished their the First Continental Congress creating all of this, creating the Constitution. And so it fell to the first Congress to create all of those things. He also lists creating offices of the Secretary of War, his chief clerk, creating offices within the Department of the Treasury for the Secretary of the Treasury, creating comptroller, auditor, treasurer, registrar. I mean, I can list them all off. Which, by the way, Bonnie over on Rumble points this out and says, and the Department of Education actually doesn't exist either. which someone could argue using this as a as a forebearer to it. They could argue that, hey, the Department of Education doesn't exist either because it wasn't created per statute. If you recall, I told you about this. I talked to you about this. It was actually created by, I think Andrew Jackson, but I'm not 100% certain on that. But then it was abolished, and then it came back under Carter. Carter brought it back. And then that's where it sits. So Carter should have been challenged on it immediately. But there you go. So there's a long list of things. I mean, whoa, this is good. This is really, really good. He also pointed out that times in the past, Congress has expressly created offices similar to the position that's now occupied by the special counsel. He points out that Congress created an office for a special counsel to investigate the Teapot Dome scandal and pursue prosecutions. And he also shows that there is a statute that was provided for the appointment of an independent counsel that was addressed in Morrison v. Olson. That statute, of course, has lapsed, and Congress has not since reauthorized the appointment of an independent counsel. So, yeah. He's also pointing out that it's difficult for him to see how the special counsel has an office established by law as required by the Constitution. When the Attorney General, this is what he writes, when the Attorney General appointed the special counsel, he did not identify any statute that clearly creates such an office. It's based off of Department of Justice order number, and he lists it here. He also points out that the Attorney General did not rely on a statute granting him the authority to appoint officers as he deems fit, as the heads of some other agencies do actually have. Instead, the Attorney General relied upon several statutes of a general nature, and he points out those statutes. And none of the statutes, he says, appears to create an office for the special counsel, and especially not with the clarity typical of past statutes used for that purpose. So he ripped, oh my goodness, he ripped into the whole idea of the special counsel's office. Yeah. So, he also called out the court giving passing reference to cited statutes as supporting the appointment of a special prosecutor in the United States versus Nixon, but it provided no analysis of those provisions' text, he says. And he goes, perhaps there is an answer for why these statutes create an office for the special counsel. And then he continues, but before this consequential prosecution proceeds, we should at least provide a fulsome explanation of why that is so. Well, then he continues on and he says, well, even if the special counsel has a valid office, questions remain as to whether or not the Attorney General filled that office in compliance with the Appointments Clause. For an example, it must be determined whether the special counsel is a principal or an inferior officer. If it's a principal one, his appointment is invalid because the special counsel was not nominated by the president and confirmed by the Senate. Even if he is an inferior officer, the Attorney General could not appoint him without presidential nomination and senatorial confirmation only if Congress by law vested the appointment in the Attorney General as the head of a department. So regardless whether the office exists, this is another thing why he's saying this, regardless of whether the office exists or not, Jack Smith himself was not appointed to that office properly. And that's, oh gosh, man, I love Justice Thomas. Yeah. So it's, he just ripped it. Oh, and then he continues on down here. He says, in this case, there has been much discussion about ensuring that a president is not above the law. But as the court explains, the president's immunity from prosecution for his official acts is the law. He says the Constitution provides for an energetic executive because such an executive is essential to the security of liberty. Respecting the protections that the Constitution provides for the office of the presidency secures liberty. In that same vein, the Constitution also secures liberty by separating the powers to create and fill offices. Oh, my goodness. He also says here, which this one, it really rips on him. These questions must be answered before this prosecution can proceed. We must respect the Constitution's separation of powers in all its forms, else we risk rendering its protection of liberty a parchment guarantee. Yep, there we go. Folks, he opened up the door, and now I'm going to tell you right now, it's going to go back to Cannon. Eileen Cannon is going to be is who he is talking to in this. He is literally talking to Judge Eileen Cannon right now, because I'm telling you, Eileen Cannon has not put out her opinion on whether or not he was appointed correctly. Eileen Cannon, I would not be surprised if she comes back from whatever break they're on or whatever at the next hearing and basically says, yeah, Jack Smith, you're no longer appointed, or you weren't appointed properly. You weren't appointed constitutionally. So you are now no longer allowed to continue with this procedure. So case is dismissed. And that would be the documents case down in Florida. Judge Chutkan has had a lot of stuff ripped out of hers. I mean, we had the January 6th obstruction stuff overturned, which throws that out. And now you add to that the decision that basically this has to go back to Judge Chutkan, and she has to understand or deal with the question as to whether or not Jack Smith was appointed properly. So that one's gone. This is absolutely fantastic, folks. I don't think you understand what this does. Now, the left freaking freaked the minute that this came out. And again, they are focused on the immunity portion. They haven't gone deeper into this and dug down into Thomas's opinion, his concurring opinion, where he outlines all of the reasons as to why Jack Smith is not appointed constitutionally. Now, they all of the left pundits and everything else are all talking about the immunity, the disastrous immunity ruling. This is in the Washington Examiner. And all of the articles, not one single one that I have seen so far has even mentioned the whole Clarence Thomas thing. Not one single one. The Senate Majority Leader, Chuck Schumer, called the ruling a disgraceful decision by a MAGA Supreme Court, of course, leaning into the anti-court messaging that has been adopted since Trump-appointed justices delivered the deciding vote to overturn Roe v. Wade. Even though this ruling, I mean, it's just a matter of common sense, folks. That's all it is. Schumer says treason or incitement of an insurrection should not be considered a core constitutional power afforded to the president. Okay, well, first of all, Schumer, there was no treason. That's number one. And number two, there's no incitement of an insurrection because Trump never said a damn thing. And that's assuming, of course, that there even was an insurrection. I don't know of any insurrections that happen unarmed. Let's just throw that out there. I mean, not a single weapon was found. on them. I mean, no guns, no explosives, no nothing. He continued with the idea that this decision undermines the credibility of the Supreme Court and suggests that political influence trumps all in our courts today. He is completely wrong with that. Now, the other, sycophantic leftist morons, Pramila Jayapal, unfortunately, she comes from my home state. She called the court ruling disastrous, and Representative Alexandra Ocasio-Cortez says that she plans to file articles of impeachment against all of the Republican-appointed justices and accuse them of being consumed by a corruption crisis beyond its control. Now, keep in mind, that little bastard, yeah, whatever. She could just go back to bartending for all I care. But the articles won't pass anyway. They won't pass it. So whatever. So 3 Chevy asks about, what about the Merchant trial verdict? Okay, so the Merchant trial is a state trial run. They would have to potentially show that what he did, again, that's probably going to get overturned, honestly, in the appeals court. That doesn't necessarily apply to his immunity, though, because him handling his business records was not necessarily an official act. It would be considered an unofficial act. So I don't see how the immunity case would actually fall into play with the whole Merchant trial. But that one, believe me, that one's going to go away anyway, because it's probably going to get overturned as it was. So anyway, they've continued to like rip on this, and not only on any of the representatives, the Democrat representatives, but also the entire left. In fact, Harry Sisson, who is a 21-year-old paid informant, paid shill for the Democrat Party, was talking about how Joe Biden should immediately go and send in SEAL Team 6 to take out Donald Trump, and then also go and like lean in and go into the Supreme Court and like capture all of those folks and put them in jail. So he's obviously a moron because he didn't bother to read anything, which, I mean, let's face it, most leftists don't. I don't even think they can really read, but whatever. So anyway, they just had a meltdown. They're just, believe me, today's social medias were just awesome. They were just fantastic. But hey, you know what? We on the right, we need to make sure that we, obviously I just noticed my, let's see what happened here. Yeah, I don't know what's going on. The scene transitions are not working right. But anyway, that's interesting. Anyway, all right, sorry. I got distracted by the production because that's what happens when you're a single person doing all this. But anyway, we're not done. I mean, we are not done. These were fantastic decisions, every single one of them. And it was a fantastic night on Thursday, but we are not done. We cannot stop. And the reason why we cannot stop is because of the fact that we still have the election in November. They still have tricks up their sleeve. In fact, even now, they're still debating going on in the Democrat Party in terms of replacing Joe or not replacing Joe, which that's looking like Joe is actually going to win on that one. They supposedly on Sunday, they went and had a family meeting and talked about whether or not the family members wanted Joe to stay in the race. And let's be honest, Hunter wants Joe to stay in the race because Hunter is assuming that Joe is going to have not only the power, but will also actually pardon him once he is sentenced. Now, that's the key, though, is he needs to get sentenced. He's been found guilty, but once he is sentenced, that's when Joe can actually go and pardon him. Now, that being said, okay, we on the right still have a fight. We still have something that we need to go and take care of. And one of the things that is occurring right now, this in the Washington Examiner, has to deal with mailing it in, the swing state ballot lawsuits that are still going on. We can't lose sight of these things, folks, because let's face it, the swing states are going to be, in more cases than not, going to be the crucial piece out of this election period. Because even though we've got polls, even though we have polls that are showing that Donald Trump is a leader in these races, we can't rest on our laurels here, folks. We have to continue the fight. Now, here's just some really quick of what's happening in each one of these states. And most of this is focused on, by the way, all of the absentee ballot, because of the fact that, unlike in 2020, where Donald Trump was saying, no, vote only in person, this time around, the Republican National Convention is saying, vote any way you can. Just vote. Vote it all. Vote it all, you know. And so because of that, there are some procedural court cases that are running wrong in several of these swing states. For an example, in Arizona, a state court judge upheld Arizona's signature matching and drop box procedures for mail-in voting. He went ahead and rejected, and this was in late April, he rejected 2 lawsuits from the Arizona Free Enterprise Club, which is a conservative legal group founded by none other than Bill Barr. In Georgia, in late February, the U.S. Department of Justice went ahead and intervened into a lawsuit challenging the Georgia State Election Board's deadline for absentee ballot applications under the Voting Rights Act. The lawsuit, which was originally filed by the International Alliance of Theater Stage Employees Union, argued that Georgia's deadline violates the VRA's mandate for absentee ballots in presidential elections if applied 7 days before the election. The Peach State's law requires applications 11 days before, which the union says is unlawful under Section 202D of the VRA. On June 13th, the federal judge found that the union should not have sued the state election board and dismissed them from the case. Though the case has been permitted to continue against Fulton County defendants. The court is also where Trump is facing criminal charges over an alleged election subversion plot, which, again, like I said, is probably going to get overturned or probably going to get thrown out now because of the whole immunity thing. Because that would have been an official act. In Michigan, a Michigan judge on June 12th partially sided with the Republican National Committee bid to tighten signature verification rules for absentee ballots. The judge ruled that election officials can continue to using the most current signature matching guidelines, but cannot apply what is considered a presumption of validity standard. So basically, it's just not going to assume that the person signing the ballot actually is the person signing the ballot. So that's cool. Now, the ruling, unfortunately, still allows most of Michigan's current mail-in voting procedures to remain largely intact for 2024. The judge acknowledged that a voter's signature can change one time due to age or disability, or if it was made in haste or it was written on an uneven surface. But it's going to help tighten up those in terms of that. In Nevada, the Trump campaign, the RNC, and Nevada GOP filed a lawsuit in early May to challenge Nevada's mail-in ballot receipt deadline, arguing that it violates federal law. While there's no ruling that's been made there, the Biden campaign has filed a motion to dismiss the lawsuit and is also seeking to become a party in the case. That motion argues that the receipt deadline law would disenfranchise Nevadans. And it basically, what the lawsuit is seeking to do is invalidate ballots received after Election Day, claiming that it dilutes votes and harms Republican candidates, which is pretty much true. Clark County officials, just to give you an idea, Clark County officials say that in the 2022 midterm elections, about 40,000 ballots came in after Election Day. And Trump lost the state to Biden by like 33,500. So there would have been extra time or extra ballots in there. And in North Carolina, a federal judge in January blocked part of North Carolina's new election law concerning same-day voter registration at early voting sites. The ruling affects the procedure verifying voter addresses, which critics argue could disenfranchise voters due to potential errors in address verification. The decision comes amid litigation filed by progressive groups and the Democrat Party against the law, which overall remains largely in effect. Republican backers of the suit plan to appeal the ruling, asserting their commitment to election integrity. Over in Pennsylvania, we have another grassroots organizations that sued Pennsylvania officials in late May to end the disqualification of mail-in ballots lacking a handwritten date on the envelope. The Third Circuit Court ruled that such ballots should not be counted, conflicting with previous rulings favoring ballot inclusion. The lawsuit argues the date requirement is arbitrary and disenfranchises voters. This case follows another federal suit by the NAACP challenging the date requirement as a violation of the Civil Rights Act. No other information there. And finally, in Wisconsin, a liberal-controlled Wisconsin Supreme Court in early May signaled a willingness to overturn a 2022 ruling that restricted absentee ballot boxes or ballot drop boxes to election clerk offices. The court's potential reversal could reinstate the broader use of drop boxes, which Democrats argue are essential for secure absentee voting, while Republicans say they make elections less secure. 2,000 mules, anyone? The case, which was brought by Priorities USA and the Wisconsin Alliance for Retired Voters, challenges the interpretation of state law by the previous conservative majority. A reversal may significantly affect the 2024 election in this swing state. So those are cases that are going on. But hey, we also have another victory, slight victory, in regards to all of this whole thing. So one of the things that the Democrats have been consistently pounding the pavement on has been the idea of abortion and the abortion laws. You remember one of the biggest things is Roe v. Wade got overturned. They all blame Trump for that, of course. And because they all blame Trump, they are claiming that this November is going to be Roe-vember. That all of a sudden, all of these women are just going to like change. You know, some of the women that voted for Trump before are just automatically, oh my gosh, he overturned Roe. I'm done. I'm voting for Biden because, you know, I want to have the right to kill my baby or whatever it is. But anyway, there was a poll that came out and the Dems have been like hitting on this for a good long while. I mean, oh my gosh, I see it almost every single day. Well, here in Breitbart, there was a poll that came out that the Democrats' advantage on abortion has statistical insignificance. Do you want to know why that is? Do you want to know why that is the case? It is literally because of the fact that Donald Trump has basically said and maintained that he wants the states to decide and that it isn't something that he is interested in, that he won't sign an abortion ban. And yet the left keeps touting it, saying, oh yeah, there's going to be an abortion ban. It's going to happen. Well, like I keep pointing out, Roe, the overturning of Roe, put that decision back in the hands of the states. That's where it belongs, because our wonderful Constitution has literally nothing in it about health care, has nothing in it about abortion as a requirement for the federal government, a mandated federal government responsibility. It doesn't have it. And so that's why the Democrats are losing this advantage, because it's now back to the states where most people think it should have been in the first place. Nearly half of voters say they are pro-choice, this from the piece, Democrats' advantage on this issue has dwindled to a statistical insignificance, according to Rasmussen reports. The latest survey from Rasmussen found 45% of likely U.S. voters trust Democrats more to handle abortion than Republicans, while only 43% trust Republicans more. And of course, 12% are undecided. But this is why, or this is where it comes into play and is very important. The Democrats' advantage on the issue is actually down from a 4-point margin, 43% to 39% in January, and has shrunk dramatically since last November, when Democrats led by 11 points on the abortion issue, according to the survey report. The survey found that nearly half, 49% of voters consider themselves to be pro-choice, 42% say they are pro-life, and 10% are sort of unsure. These most recent findings have not varied since Rasmussen polled on the subject in January. So once again, I've been pointing out again on social medias, abortion is not the big issue that Americans are caring about. They are caring about their pocketbooks. They are caring about the immigration laws or lack thereof in immigration. They are caring about things like this. So here in the New York Post, and this is actually in reference directly to the debate, because in the debate, there was a projection by President Biden where he is actually seeing annual budgets right now, or budget deficits, I should say, of $2 trillion. That's right, $2 trillion. Okay. He asserted that Donald Trump went ahead and added more to the federal debt than anyone else. So it's a leftist argument. They're kind of, they're fudging the numbers, folks. They're fudging the numbers. Because according to the left, they think that if Trump wins, he's going to run deficits twice as large as what Biden is. But here's the problem. And of course, this was one of the lies I think that I hit, by the way, one of the lies that I hit when we were watching on the moderator. So debate moderator Jake Tapper joined at the chorus of federal finance falsehoods when he claimed that Trump had approved $8.4 trillion in new debt, while Biden's actions will increase the debt by a merely $4.3 trillion over a decade. Well, they're actually wrong on that. He was referencing a report that was by the left-leaning Committee for a Responsible Federal Budget, which twisted and turned, of course, twisted and turned the debt statistics in just all kinds of ways in order to reach this incredible conclusion. The reality, though, is that the forecast, so originally the last year of Trump's administration, in 2021, the Congressional Budget Office projected that the federal debt would essentially reach $35.5 trillion by 2031. Now that is essentially over the next decade, okay? However, today, the latest estimates from the CBO project state that the debt will hit over $42.5 trillion by 2031. That's just 3.5 years into the Biden administration's tenure. So wait a minute. So if you look 35.3 under Trump and then 42.5 trillion under Biden, that's a difference of basically almost $7 trillion, folks. Look at this graph. If you're listening on the audio program, you need to go and head on over to rumble.com and find the American Perspective channel and check this out. So this is from also the Congressional Budget Office and the Council of Economic Advisors. So in other words, the CBO is now expecting the debt to be 7.2 trillion higher than what it had projected when Trump left office. And this is all due to Biden's reckless spending policies that are there. Treasury Department figures also show that the debt is growing much faster under Biden. Over Trump's entire term, including the 2020 spate of emergency COVID spending, the debt increased by 7.7 trillion, which is a staggering total. However, about 15% of that debt total was the result of the Treasury's choice to keep additional cash on hand during the pandemic. Wait a minute. They created... So here's what happened for that. Did you catch that? The Treasury decided to keep additional cash on hand during the shutdown, during our 2020 shutdown. So former Treasury Secretary Steve Mnuchin, unsure of how the tax revenue would be collected during 2020, borrowed well over $1 trillion, but kept it in reserve without ever spending it. Biden, however, went ahead and spent that reserve and then borrowed another $7 trillion on top of it. What? Instead of simply allowing that one-time emergency COVID spending to expire, Biden and the Democrat Congress continued to spend at the same COVID-era level, thus institutionalizing multi-trillion-dollar deficits. Yeah, we haven't had multi-million-dollar deficits in decades. Accounting for the changes in cash balances at the Treasury, the debt actually rose by 6.5 trillion during Trump's entire term, and it is now up 7.9 trillion in less than 4 years under Biden's tenure. So there you go. Once again, Joe Biden lies. The Democrats lie all about this. Now, worse than that, of course, is that the Treasury has announced that it anticipates needing to borrow another $800 billion from July through September of this year. Wait a minute. July, August, September. $800 billion in 3 months? And apparently following off again by hundreds of billions more from October to December as the federal finances further deteriorate. Yeah, they're guessing that Biden will likely see will oversee a net increase of the debt more than $9 trillion in a single term, which will be a new record, by the way. Now, he wanted to spend more. He wanted to spend $2 trillion more, but the House, if you recall, the GOP controlled House blocked most of that added bloat. Yeah. So we cannot give this up. We cannot let this pass. We have to continue to fight. We have to continue our fight. Let's take the wins, but let's make sure that we continue the fight and we take it back to them, and we make sure that we not only win the presidency, but we also have to win the Senate and keep control of the House and expand our control. of the House. That's what needs to happen. All right, so I'm going to leave you on a funny note here really, really quickly. There was a gentleman, this is, let's see, Sky Jultster, Jultster, I believe, who posted a video on Twitter. I don't know if this is where it came from or what, if he did it or if somebody else did it, but he posted this on Twitter. Now, for those of you, just kind of set this up, for those of you that don't know, they held kind of an after party type thing for Joe Biden after the debate, where Jill was sitting there and saying, you know, "Oh, Joe, you did such a great job. You answered all of the questions. That's fantastic." Sounding as though she was talking to a 5-year-old, which, I mean, let's face it, mentally, that's what he's doing. But in that, she also made a couple of moves and made some gestures. And so what this gentleman did, at least I think it's him. Yeah, he's taking credit here. SKJULTSTR. He went ahead and put it to a different soundtrack. Let's take a listen to this. See if anybody remembers this soundtrack.
And then we're going to Washington, D.C. to take back the White House. Yeah! And then we're going to Washington, D.C. to take back the White House. Yeah! And then we're going to Washington, D.C. to take back the White House.
Could this possibly be the Howard Dean scream death of his campaigning? Oh my gosh. Whoever this guy is, whoever this person is that did this, man, that was very, very clever, and it was perfect. And you know, the thing about it is all the memes have been coming out since that. And yeah, this is just fantastic. I just want to listen to it one more time just to leave you on a good note.
And then we're going to Washington, D.C. to take back the White House. Yeah!
Oh my gosh. Oh, that is hilarious. That was very, very clever. That's all I got to say. That was incredibly clever. All right, folks, that's the end of the program for me tonight. Do me a favor, if you haven't already, go on over to rumble.com, get yourself an account. It is free. And once you are there, make sure you search up the American Perspective channel and hit that green follow button to make sure that you're notified every time I go live. If you are already there, please do me a favor and hit that thumbs up button. That is one of the ways that Rumble will rate this video. Is the more likes that I get, the higher the ranking goes. And I would love to see myself on the leaderboard or even the editor's picks page. That would be awesome. And we will go ahead and see you tomorrow night, 5 p.m. Pacific, 8 p.m. Eastern time, right here on American Perspective. Have a great rest of your evening. Good night, everybody.
The previous broadcast was produced and is owned by Active Eye Media LLC. All rights reserved.